Hello, everybody. We are yet again covering this idiot by the name of Darrel Edward Brooks. And now he's basically here trying to challenge the judge on case law. So he's looking at a quote unquote mistrial. So let's dive in. And y'all know me. I'm going to debunk the hell out of this no hairline. And if you look at his hairline, it looks like this. Look at his hairline. It looks like there's horns on the left side and there's horns on the right side. That's the horns of evil. Satan. Let's dive in.
Look into a mistrial and also any alternatives along those lines, short of that or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. And as you know, because of my...
Wait a minute, y'all. Did y'all hear what he said? He's looking into a mistrial. That was his entire gambit. His gambit was to cause a mistrial. Why do you think he talked to the judge in an inappropriate way, reprehensible way, his disrespect of Judge Darrel? That was the purpose of mistrial. So that way she could lose her cool and he could win this by technicality of a mistrial. That was his whole plan. Let's keep going.
Status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez.
Here we go.
22 U.S. 579. And that specifically, I think it's referenced, because that one is pretty old in itself, but it's referenced in a lot of the other
He don't know what he's talking about.
case laws that I actually found. I think...
Man, whatever, bro. Listen, this ain't helping you. So what he gonna do is try to challenge the judge on case law. Okay, come on. It ain't gonna help you. You still going to jail. I don't care what you found on case law.
And I could be, if I'm interpreting this incorrectly, I apologize.
It's incorrect.
They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that
You don't know what you're
each
talking
one
about.
references in regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion. And,
You ain't getting out of this.
I think that's kind of like the leading one.
Just
Also,
get to
I
the
looked
point,
at,
Darrel.
Brown versus Rushton, 572 F.3D.
Hold on, y'all. He really think he about to say something. He think he about to outsmart the judge. Come on, come on with it. Y'all remember when he was reprimanded by the judge during the victim impact statements, and remember he said, "Come on with it, come on with it." Well, what am I saying? Come on with it, because this ain't no challenge. This is not going. You're not going to win, Darrel. He's bringing up case law, and the judge is going to refute all of that. You got to remember, he's winging it. You got to remember, he's not an attorney. He's an inmate fighting for his life.
198,
but to no avail.
which speaks to the language is basically it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES.
Okay, whatever.
917 F2D 388.
Your point.
And that speaks of potential for an impartial verdict.
You're still going to jail.
Specifically, it says along the lines of impartial verdict. If an impartial verdict can be reached, or if a verdict of conviction could be reached, but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington.
Keep on looking.
434 US 497. And that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury which may be tainted by bias. And I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor,
he don't know. He don't know what he's talking about.
It's pretty clear.
Man, shut up, man.
If not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day.
That's BS.
The language.
Come on, man. Look, come on. This is going to be refuted by way of this being a public trial. This is a public trial. It's on court TV. Everybody has access to this. Everybody has seen this. Everybody is making posts of this. Everybody is come on. So he's trying to blame a juror for intimate knowledge, somebody that knows. We all know. And it's going to be refuted. Keep on.
Directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning.
Extremely concerning. It's extremely alarming, but it's not extremely concerning to him that he killed Jackson Sparks, that he killed 6 people, he injured 70 people. That's not concerning to him. But as long as, this alleged juror with all this intimate knowledge would write a Reddit post, now all of a sudden this is extremely concerning. Oh, that's a crap. Please, you lie, man.
Extremely concerning. And then going back to some of these
man, shut up.
Case laws that I cited, it talks about
BS. Stop him, Judge.
Something to the effect of
he's talking crap.
The ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it.
Yeah, misinterpretation.
Obviously, I'm not educated in a lot of
obviously
the laws in itself, but
apparently,
how I was interpreting it.
You don't know shit.
This is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at. Look at some options. Look at some alternatives. And those case laws I cited talks specifically about that, options that You, Your Honor, can look at and use your discretion to see if it's appropriate.
Yeah, she's going to
in any
refute.
way, but I'm extremely concerned about this.
Y'all see how he's so concerned about what could potentially help him relative to, watch this, he talked about alternatives. That's why he said, I want to look at, well, he said alternatives. He was really meant to say alternatives. He's only concerned relative to that which will appease or help and or deputize him. He's not concerned about the people he killed. He's not concerned about the loss that the families have to deal with. He's not concerned about that because that doesn't reflect him. Mr. Brooks is only concerned about that which appeases and or deputizes him. In other words, F everybody else. It's all about me because this is concerning. It's concerning. It's alarming.
If anything, for cautionary reasons,
Cautionary.
I believe, Your Honor, that you definitely should.
Wait a minute, hold up. You notice he said cautionary reasons? Why didn't he drive with caution? See? He wouldn't have drove over those people and killed those people if he was driving with caution. So now how is he going to undermine caution and then argue cautionary? That is BS. Yo, this dude is crazy. And does he think the judge is going to honor what he's requesting right now? Does he really think that she's going to dismiss this in his favor, irrespective of what he caused, even though he's arguing cautionary? That is BS.
Take a look at everything I'm saying here in these case laws and
BS.
What's the request, though, that you're making based upon the case law that you cite?
He wants to dismiss.
I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
Relief.
relief?
Like, what are you asking me to do based upon the information that the limited information we have about the Reddit post
He wants to dismiss.
in this trial?
I guess my request would be, because of the concern of this,
The concern.
to look at a mistrial,
BS.
or at the very least a discharge of the jury.
No, ain't nothing. That's
So
not happening.
this can be resolved. This is alarming.
Alarming. Can you listen, yo, audience? Can you believe that he actually used such a word, alarming? Like, wait a minute. What you did when you killed those people, that was less alarming versus this so-called Reddit post that you're claiming came from a juror? And how could it come from a juror if everything was taken from them? Their electronics was sequestered. Anytime that there was sequestration, that means all of anything they had that would be an apparatus is seized. And so now you are alleging that this Reddit post came from a juror, which is no basis for that, given the sequestration of their belongings. But all of a sudden, this is alarming as opposed to what you really did that was really alarming. That's what I don't get. Let's keep going.
This post, and I don't know what Reddit is, to be honest.
You know what it is.
I've never heard of it or used it.
You know what it
I
is.
don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different.
Wow! Did you hear what he said? It could snowball into something totally different. Well, that kind of out of control. That he's doing is talking about himself. That's a reflection of him. See, in preliminary, he said that he wanted to represent himself. But now during the trial, now this has turned into something different. In other words, he doesn't understand now. Even though he gave up his own attorney, but now it's turned into something different. There's a metamorphosis now. Now he changed. There's a snowball effect. Now it's something different. Oh, now I don't understand. Even though I willingly and arrogantly got rid of my attorneys. But now the going has become tough, even though I was admonished and or ill-advised to represent myself. But I did it anyway. Now this has become a metamorphosis of something different. Now I don't understand all of a sudden. BS.
I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent the who alerted the clerk, of course, to this post. I think his name is in the email.
Darrel,
but then
whatever.
that even begs the question of how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and
You're so concerned.
I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming.
Alarming.
And if there's a chance that there can be hidden.
Man, shut up. When you drove in that parade and killed those people, that was alarming. That was alarming. What you did. The hell with the Reddit posts. What you did was alarming. How can you undermine that and be worried about a Reddit post? This dude is crazy if he think Judge Darrel's gonna forfeit his crap.
Bias in this jury, it needs to be addressed now rather than later.
Whatever. Let's refute it. Come on, Judge.
This is very concerning.
Whatever. Come on, Judge Darrel. Refute.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond,
Let's hear from the state.
and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrel. That's the copy that
Justice
the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster.
Exactly. Did you hear what I said? In other words, Attorney Woodchild is pointing out the sequestration. Their devices were sequestered. In other words, they did not have access to write any posts. So that refutes all of that. That the state is coming in to refute what Darrel is asserting.
I think that puts that issue
To bed.
pretty much to bed. It's still
Exactly.
obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason
Exactly.
why we should doubt the jury's being unbiased in this case.
Exactly.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's investigation, then that clearly says that something is amiss.
No.
We have 15. We have 15 jurors. There's still
Okay, 15 jurors, but the point is, their belongings were their electronics were sequestered. And so if it was sequestered, then how can they have access to write a Reddit post? What does he not understand? You were just refuted.
too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know.
We know.
It's unfair to say that the issue was put to bed when there's still so many questions left out there.
Now he's talking in circles.
I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever this thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial.
He can't say intimate knowledge given that this whole trial was public. We all see what's going on. We all have intimate knowledge. We're making posts of you. I'm making a post of you right now, and I'm getting ready to upload to my audience. Why? Because I have access. And guess what? I'm not a juror. And so if this is public, that means we all got access. So what you're saying is refuted.
I don't think. I mean, common sense would tell you that this is
Oh, please.
someone who's very.
Please don't mention common sense, Darrel. Common sense would have said for you not to represent yourself given all the felonies that you are facing. Common sense would have said, oh, I need to keep Attorney Perry on. Don't you dare talk about common sense. Common sense would have told you, well, why do you keep asking about subject matter jurisdiction? If you were convicted, you're convicted. So that means subject matter jurisdiction was irrelevant, given that Judge Darrel had subject matter jurisdiction to try the case. So why did you keep bringing it up? Common sense would have told you to not keep asking the same question on direct when it was being objected by the state and sustained by the judge. That's common sense. So let's not go down that road of common sense, because you was just as dumb as they come.
Very close to the case, whether they were intended to be funny, whether they were
whatever,
intended to
man.
try to
Shut up.
Prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think.
Darrel, give it
They
up.
point to certain language in the case.
He is really trying to fight his
They
way out
make
of it.
references to saying when we were in the room, they got certain feelings from when we're.
Darrel, we all see this. We all have intimate knowledge of this court case. It's on court TV. It's all around the world. You can't say that you can't guarantee that it's a juror that has intimate knowledge. What you're saying is absolutely nonsense.
They specifically refer to themselves and a group. That would be we, plural.
He is really think he gonna win this, man. You a fool.
They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you.
Watch this. They attack you. Well, what do you think you were doing? You were attacking her. What did you say to Judge Darrel? How can you be a judge? How can you even be a judge? So how you gonna try to be on her side when you was attacking her at the same time? Man, you was a fool. You think Judge Darrel's this dumb to fall for what you saying? Oh my God, this dude is a fool.
This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it.
He is a fool.
This is clearly someone with intimate knowledge of the case and what's going on.
Darrel, we all have knowledge. Oh my, come on. I need the state to come in and refute him quickly.
There's no other way. There's no other way to interpret
all right, shut
this.
up.
You can tell by what they're laying out in the language that they're speaking.
Whatever.
With,
shut up, man.
that this is clearly someone close to the case. And
we all close to the case.
Because of that, it still has to be... I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone?
What if it wasn't?
What if it turns out?
What if it wasn't?
That more people are involved in it than just whoever this anonymous person was who left the post.
But what if it wasn't, Darrel?
It's too many questions and it's too concerning.
It's not too concerning and it's not too many questions. Given that this is a public trial, everybody has access of it. Instead of him worrying about an alleged juror that's supposedly alarming or too concerning, how come he's not concerned about the lives that he took? Why is everything all about him and him getting out of this, as opposed to the reality of the situation? That's and Judge Darrel is way ahead of this. The Judge Darrel knows this because she pointed a lot of this that he's saying. She pointed this out during this sentencing. Darrell Brooks only cared about himself, only cared about his own exile. F everybody else. F everybody else. F what I caused on these families. It's all about me, and it's all about me getting out of this. Judge Darrel ain't falling for this. She ain't.
What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks, and even in court days leading up to the trial, we've never had anything like this happen.
Yeah.
Nothing like this has been brought to your attention. Nothing like...
Yeah, well, guess what? Nothing like what you did has ever happened. I never heard anybody see people in a parade and drive and kill those people. How come? If you got enough sense to think that this ain't never happened in terms of an alleged juror that you're alleging that would make a Reddit post, how come you ain't got enough sense to say, man, driving through a parade has never happened? How come you didn't have enough sense to not drive in a parade and kill those people? But all of a sudden, now this is alarming and this is surprising to you, that you're alleging that a juror wrote a Reddit post. Man, please, man, shut up. You're a disgrace.
this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled.
All
a
right,
prank.
Judge, can you?
Is that because
can
they
you
were
stop
found
him?
out? I mean, it begs so many questions.
No, it does not.
It's too uncertain. It's too concerning.
All right, I'm tired of the bullshit. Let me hear from the judge.
It's
Advising the parties.
All right, let me hear from the judge.
Make conclusions.
it's very clear to me.
Whatever. Clear to
Let me
me.
address your concerns, sir. I cannot make conclusions at this point
Right.
about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror.
But it
I
wasn't.
remind you though, every single day these jurors were read the bulk of jury instruction 50.
Right.
They all took an oath, and I have no reason to doubt that they would violate that oath at this time.
Exactly.
So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative.
Exactly.
At this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the Clerk of Court's office receive emails regarding this, it sounds like the District Attorney received emails. I may have even gotten one, I don't remember the time, it was later, regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it, and I simply forwarded that email onto law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial.
I don't either.
I do not see grounds to discharge the jury.
We will continue.
And that is how I will address it at this point.
Look at him. Look at him. He looked mad because he really thought that he was going to shut this joint down. He really thought that he was going to get out of this. Notice she said it was speculative. Judge Darrel is not going to rule on that which is speculative. She rules on the facts. That's why she said this is speculative and remains to be speculative. You know, the state had a stronger case given, what did they say? They said there's no reason to doubt. There's no reason to believe that a juror would write such a post given that there has been a sequestration of their electronics. All right. Judge Darrel came in and said that they made an oath which would not give her any inkling or any belief that they would violate that oath. But here Darrell Brooks comes in with speculation in the absence of facts. And how many know in the court of law, you cannot win on speculation. You got to win on the facts. And he didn't have it. And look at that look. Yeah, he look. Yeah, because he know. That tactic didn't work, did it? That's why she said, I'm declining to do so. I'm declining to grant you your relief because it's still speculative. Watch this. And remains to be speculative. Listen, audience, y'all comment on this. I would love to read the feedback relative to what you have to say concerning this idiot in the person of Darrell Edward Brooks.